Where is everyone?
Astros.
Oh, you're funny! I do like small class. We get called on twice as much today. We have basically half the class absent, which is quite a lot. Okay, they're missing class. Their fault. Any questions in your minds? Anything in your minds? Yes, sir.
So with the sign up to review.
Yeah. Okay. Let me talk about that. So I will have all of your midterms graded by Monday. So a week from yesterday. You'll pick them up from Cindy, whose office is across the hall from me. I'll give you your grade written right on top of your actual paper. I'll have it printed out for you. If you don't know your exam number, don't remember your exam number, go get it. The registrar will give it to you very easily. The reason why you'll need your exam number is when you pick up your paper, your name won't be on the paper. You'll need to know your number. So pick up your exams. Okay? That's first. Get your number, be ready. Monday morning, I'm going to post the A+ answer along with the question itself. Before you meet with me, you are obligated, please, to review your paper and compare it to the A+. Now, the A+ is not perfect. I've never given a 100. Keep it 100. I've never given a 100 in all my years of teaching. It has not happened yet. I've given maybe 95, 96, haven't given 100. So don't treat the A+ paper as gospel, right? It's not perfect. It's entirely conceivable that you got something that that person didn't. More likely, my exams are written to be open-ended. There's no one right answer. Okay? What tripped up a number of you, and you'll see this when you get the scores, is the word limit. A number of you just ignored them. I stopped reading at 1,000 words. A lot of you, I didn't get to question number 5. I just stopped reading. So if you see bad grades, that actually explains the reason why.
Examify does not have a word count on it like Examsoft did.
I couldn't find it. You said a click.
You have to click and like hover over it.
You have to click on the...
There's a way, and I told you if you don't know how to do it, go talk to the registrar. So now's your opportunity. And if you can't figure out the word count, this is called a finger. 1, 2. I'm being serious. It takes maybe about a minute to count 1,000 words. It's not very long. It's not an excuse if you can't figure out use technology. Yeah, I know. She told me. Yeah.
All right, so I messed up, and I didn't read the email all the way through. But I just
Mark, one at a time, please. Only one person speaks at a time. Go ahead, Keith.
I just put my name in.
That's fine. Anyway, so most of you ignored my email, which is fine, but I'll figure it out. I sent you a link. I put out 114 time slots between now and November 13th. But half of them are already taken up. If you haven't signed up yet, do so today. Because if you keep waiting, you'll be stuck with a crappy time slot. I will basically be here till 9 p.m. Every day between now and the end of the semester. If you don't sign up for a slot, you'll be stuck at 9 p.m. I'll be here. I'll be happy to talk to you. If you don't sign up for a slot, I will assign you one. And it'll probably be at 9 p.m. at the end of the day. The way to do it is very easy. So this is the link I sent you. It's called Doodle. Very simple program. Here, let me bring it up for you to show how it looks for a non-admin account. So you click the link, and what you'll see is a place. You type in your name. Type in not only your name, but also say ConLaw and your exam number. I don't know if I know which section you're in. I don't always remember. I know who you are. I don't always remember which class you're in. It's the damnedest thing. I know who you are. As you scroll through, you'll see that there's little eyeballs with a little line through it. That means the slots are taken. So if you notice, almost all of the first week are gone already. They're already gone. You have to scroll all the way down till, here we go, November 7th. So if you waited this long to sign up, you're stuck till the first week in November. I'm sorry, but that's how it goes. So you select here, you go check that, and now you're stuck on November 7th at 6:30 p.m., right? Again, sign up, please. If you don't, I'll put a slot for you, and you might not like it. But all these are basically at nights and on weekends. I don't like it, but it's the only way to meet with 110 odd students of you. Okay? Questions on that? It's very easy to do. Much easier than writing your name on a piece of paper on a door. This will actually sync to my calendar so I can see who you are and very easily know it. Any other questions on that? Okay. Sign up. All right, let me turn up the attendance. Here we go. I want to start us off with a question today. This is your question for today. And it's an easy true or false. I suppose it's easy. Question is this. All racial classifications are unconstitutional. True or false? Is your question. All racial classifications are unconstitutional. True or false? Alright, give it a few seconds. Only 20 people here. That's about it. Okay, I don't remember. David, you up next? What's your answer here, my friend?
False.
Okay, why are you saying false?
Korematsu.
Korematsu? Are we supposed to cite Korematsu?
No, but they did.
Who's they?
Supreme Court.
Where?
In, not the Bakke case. In the Bruder.
Okay, so you think under Korematsu, a racial classification is valid. Aaron, what did you put here?
I put false,
Okay.
just because a racial classification in itself wouldn't be unconstitutional. Like, it wouldn't be unconstitutional to call a white person white, would it? Like,
Well, what's a racial classification? Maybe my question wasn't specific enough. What's a racial classification?
I was under the impression that it meant, just classifying someone by race.
You mean like the checkbox on your application, something like that?
Yeah, like that. That would be.
Jackson, what's a racial classification in your mind?
Not a good classification, but I guess putting people into categories based on their.
And who putting in specific? Who's doing the putting?
Well, it depends on what institution, maybe like for today, I mean, like schools,
So during government, right?
government, yeah.
So what'd you put here, true or false?
I put false.
Well, Melissa, what was your answer
I
there?
put false as well.
You went with true? Mark, give me your answer.
My understanding of racial classifications, although Aaron's argument was compelling, was more in line with what Jackson brought up, and I feel that racial classification on its own is unconstitutional, but after all applicants have been received and considered to be qualified, then that can be taken under consideration for the diversity of the room.
Okay, anyone else put true on it? Raise your hand. No one else, huh?
Well, I put false, but I really debated it because although the court in a couple cases found racial classifications to be permissible, I agreed more with Justice Thomas in his many dissents that anytime we are using racial classifications for anything, it should be unconstitutional.
Okay. So the answer here is false, right? The answer is false. Let's see what we got. Okay, Mark, you're 1-1. But that's the easy part, to say the statement's false. The hard part is to explain why. And I want to use an example, right? What is the driving age in Texas? Is it 16? Is it 17? When do you get your license? When do you get your learner's permit? 15?
15.
Okay. 14?
You can, you have special, like, if you're in a
Okay,
single parent
so
home.
let's just say, make it easy, let's say 15, get your learner's permit at 15, and then your license at 16, right? Okay, that's the rule in Texas. I grew up in New York. In New York, you get your permit at 16, and your license at 17. Now, was that fair, right? That all of you were able to drive when you were 16, and this schmuck could get his license when he was 17 years old? And in fact, make it even worse, you can't drive in New York City with a learner's permit. It's illegal. I have to go like to New Jersey or like Westchester to drive and practice. I did it anyway, illegally. But you have to basically leave. Remember this, right? Mm-hmm. You cannot drive with a permit in New York City within the 5 boroughs. New York City is 5 boroughs: Manhattan, Brooklyn, Queens, the Bronx, and Staten Island. That's what New York City is. Now, what am I up to? Cortland. Is it fair that, you know, in Texas, 16-year-olds can drive, but in New York, you have to be 17?
I think so.
Why?
The states have their own power.
But how, if a Texan can drive at 16, they're responsible. Why can't a New Yorker? Can the government classify people based on race? I'm sorry, based on age, right? Can the government say we're going to allow all the 16-year-olds to drive in this state, but here in this state we're going to allow 17-year-olds to drive? Can they classify people based on age? Is there any problem with that?
Federal government?
State, federal, I don't care.
I don't think so.
But they do though, right? Can a 12-year-old walk into DMV and get a license? So the government does class people in. Okay? Mark, why is it not particularly objectionable when the government groups people based on age, right? Why is it not like that big of a deal? I mean, we have these license laws in every state, 15, 16, 17, whatever the law happens to be.
Well, I guess, looking over my outline, Harlan's dissenting opinion in the lottery discussion, you know, it's not enough to determine if a law is fair, it must also be just.
So you can go challenge the 12-year-old that let get a license?
Well, I'm thinking like, you know, depending, you know, Texas is a big place, there's a lot of open road, you know, it might be easier to drive here than it is in New York, where it's...
So there might be a reason why New York has one driving age and Texas has another.
Right.
Maybe availability of public transportation,
Right.
right? Maybe alternative routes of travel, you can go take a subway or take a bus.
Mm-hmm.
Okay. Crystal, let me ask you another question. Let's say a state passes a law that says, females can get their license at the age of 15, but males get their license at the age of 16. And they say, look, we have studies showing that girls are safer drivers. We'll look at insurance premiums, right? If you're a teenage girl versus a teenage boy, guess who's getting higher insurance rates? The guy, right? This is we can prove this with actuarial certainty. True, yeah. Maybe you guys can help me accept it, but generally, generally females have lower insurance rates than males. It's true.
And they say.
Crystal, so is that sort of law constitutional?
I would say yes, because the means are tailored to the ends. So as long as they can prove that the means are tailored to,
Well, what are the means here? Let's break this down.
the means are restricting, or I guess you said it's insurance rates, so it's charging males.
No. This is a government law that you get your license at 15 for females, and your license at 16 for
So
males.
then the means is deciding which age males
Good.
versus females get their driver's license.
And then what's the government's end there? What are they trying to achieve there?
Safety on public roads.
Safety on public roads. If the government can show with certainty that men are less safe than women at the age of 15, they can delay. Okay. So what I'm seeing here is you're saying, well, maybe there's a reason why New York might want to have younger drivers versus Texas. And then Crystal says, well, maybe there's a good reason why female drivers should start driving earlier than male drivers. So, Martin, next hypothetical, right? African American drivers get their license at 18. White drivers get their license at 17. What happens there? Is that a good distinction? Does that work?
No, I don't think it is.
Why?
Because that doesn't apply unilaterally to all people groups based on something that you can quantifiably say there's a good difference in.
So you're saying there's no good difference between black drivers and white drivers to justify this law?
Correct.
Okay. So I want you to look at what happened here, right? When I was talking about age, right? A 16-year-old in New York is just as mature as a 16-year-old in Texas. No, maybe not, Mark, right? But, 16-year-olds in one state or the other have the same level of maturity. But it didn't bother us when the government was classifying people based on age. Why? Everyone grows out of being 16, right? Eventually, everyone turns 17, God willing, right? Maybe you die, whatever. But eventually, people age. And then with Crystal, though, I think it was a little bit more of a tough call, right? She's like, well, you need some sort of precision, right? That it's more likely than not that a male driver at 16 is dangerous than a female driver, that we look at insurance rates. But there was like a hesitancy in her answer, because it's certainly the case that some female drivers are going to be reckless. And some male drivers are going to be very safe and studious, right? So can the government justify this sort of classification? Okay. Then the third example that I gave you concerned race. I said a white driver gets his license at 17 and an African-American driver at 18, right? And then Martin says there's no conceivable basis why that's the case. There's no justification why race is a determinant for someone's safety behind the wheel, right? I just taught you two to scrutiny, right? You didn't even realize, but I just did. What the Supreme Court has done over the last, 50 or 60 years is to look at the Equal Protection Clause based on the type of classification, right? They look at the type of classification. So we'll start off with age, right? Age. When you group people by age, it's not really that big of a deal. People don't put much weight onto it because eventually everyone ages, and there's a good reason why kids can't do stuff, right? We have contract law. If you're under the age of 18, you're not mature. You can't have the capacity to contract, okay? We call age a non-suspect classification. What does it mean that's non-suspect? We're not suspicious, right? When the government passes a law telling kids they can't do stuff, there's probably a good reason for it, because kids are mature, okay? When you have a sort of non-suspect classification, we apply what we've called rational basis review. And we've done this before in other contexts, right? What rational basis review means is, if there's some reason why this is valid, the law survives. It doesn't have to be a perfect reason or even a good reason, right? If we say that New York has public transportation and Texas doesn't, it's fine. But again, if you're in Dallas, for example, they have very good public transportation there. And if you're living in upstate New York, there's no public transportation there. So the law doesn't have to be precise, right? It's a general sense of, well, there could be a reason why if you're in a crowded city versus, a suburb. So with age, we have what's called a non-suspect classification. The second example I gave was gender, right? Gender, male, female, right? This is what we call a quasi-suspect quasi-suspect classification. What does quasi mean? Maybe yes, maybe no, medium the road. When the government starts classifying people based on gender, we get a little bit more suspicious. Now, Crystal gave an answer, said, yeah, no problem. Look at insurance tables, right? But I'll give you another example of a case we'll study in a week or two. What if you made the drinking age for girls 18 and the drinking age for boys is 21? You could say the same thing, that females are more mature. They're less likely to do dumb stuff, right? Maybe you agree with it, maybe you don't. No comments, not looking for any comments. Right? Maybe you agree with it, maybe you don't. But the court actually struck down such a law that was from Oklahoma. And they said this law is based on stereotypes, that girls fit into a certain stereotype and they're these pristine things and they can do no wrong. Look, if you go to college, girls get drunk just the same, right? It's not a male-only affair. So if a law is merely reinforcing a gender stereotype, the court's a little bit more suspicious. For these categories, we apply what we can call intermediate scrutiny, right? Okay? Intermediate scrutiny. And it's exactly what it sounds like. It's somewhere between rational basis and strict. We'll get to the details in a little bit. But then we have something like race, right? When we have a racial classification, we call this a suspect classification. And what does suspect mean? It means we are really suspicious, right? When the government starts lumping people based on race, they probably don't have a very good reason for doing so. And you look at it very closely. Very, very closely. And this is the application of what we now know as strict scrutiny. Right? Now, David mentioned Korematsu a couple minutes ago. He mentioned Korematsu. Korematsu was a case that involved an express racial classifications. Remember the posters, right? All people of Japanese ancestry report to this location. Remember those posters, right? express racial classification, no doubt about it. And indeed, the court upheld it, notwithstanding this application of strict scrutiny. Why? The court said national security justifies it. Okay? But that's not the only case where the court has actually upheld racial classifications. Your readings for today illustrate instances where the court has said, okay, the government's sorting people based on race, but it's okay here. And what I'm talking about is in the context of education, affirmative action. So we'll go through these tiers in much more detail today and the next class after that. But you always have to ask yourselves when you get an equal protection question, what is a classification, right? How is the government lumping people in? And depending how they're grouping people, then you can figure out the correct tier of scrutiny. We'll go through this in more detail later. But for today, it's enough to know that when you have a racial classification, such as in the affirmative action cases or the Korematsu case, we afford strict scrutiny. And the only instances in the Supreme Court's history where a racial classification has been upheld has been Korematsu and Grutter and Fisher. That's it. In all their cases, racial classifications have failed. Okay, any questions on this so far? Okay. So I'll begin by giving a little bit of background on affirmative action. This is a phrase that virtually I think everyone in this room knows, but few people actually think about what the word means. It's like Social Security. Everyone knows what it is, but wait a minute, it's securing society. What does it even mean, right? So what does the phrase affirmative action mean? The genesis of this phrase is an executive order by President Kennedy from 1961. And it required government contractors to take, quote, affirmative action to ensure that employers are not being discriminated against based on race, color, or national origin. What does that mean? It's not enough to eliminate discrimination. They must take affirmative action or steps to ensure that doesn't happen. And that can take several forms. It can take the form of a quota. What's a quota? When you're hiring, say, for 50 people, X number is set aside for certain minority groups, right? It can take the form of a holistic review, which is what was at issue in the Michigan cases, where race is considered as one of many different factors. It can take this many different forms. But the question always boils down to this. I think it was Aaron's point a minute ago. When you're applying for some sort of government position, whether it's a job or a student position at a university, and they ask you for your race, and you check that little box, what's the significance of doing so? How is the government using that information to group you? Okay, everyone with me? Okay. So there are three major cases that we're covering today. Josh, we have like 6 cases. There are 3 major ones, right? So the first one is the Bakke case. This was from, 1978. I'll be off by a year or 2. And this was a case about the University of California's medical school. We then fast forward 25 years to 2003. I was in college. I remember this case when this came out. And this involves the University of Michigan. I was actually in Michigan yesterday. It's perfect timing. This involves the University of Michigan, both their law school and their undergraduate. The third case, which again is 2 cases, but I'll consider them as one, involves the University of Texas at Austin, where I'm sure some of you went to school. What each of these cases represents is a struggle within the court to reach an answer that actually works. And I think what each case represents is they didn't quite get it. All right? So the Bakke case was a really big decision before before Grutter. And this is Alan Bakke, who graduated eventually from UC Davis Medical School. And I like this headline of Time, because it basically summarizes the holding in like 5 words. Under the holding of Bakke, quotas are impermissible, but consideration of race is permissible. Okay? Who's next? Mark, are you next? Oh, I already did. Yeah. All right. You want to give me the facts, please, on Bakke, please?
Yeah.
Thank you.
So Bakke was a white applicant for the UC Davis Medical School, and he basically said that there was a violation of the Equal Protection Clause of the 14th Amendment when he was denied admission based on his race.
Okay, very good. Thank you. So before I get there, I want to note something. As we all know, generally speaking, college takes 4 years, right? Unless you're a super senior, right? College takes 4 years. If one is denied admission to an undergraduate program and you go to a different college instead, how much time do you have to complete that lawsuit? And I'll jump forward to Miss Abigail Fisher, right? She was the plaintiff in the Texas case. She was denied entry. She actually went to Sugar Land High School, not too far from here. My first year teaching, a student of mine was a high school classmate of hers. So she was admitted to UT, she was applied to UT, denied entry. She also got into LSU. She was not happy about that, but she went to LSU. She graduated from LSU and already had a bachelor's degree. Was her case even still valid at that point, right? Why was her case even being considered if she graduated from UT? The stupid answer is she was seeking a refund of her application fee, right? Whatever it is, what you pay, $75, $100, whatever the application fee is nowadays. That was her issue for standing. That was her injury. But there was another case decided shortly before Bakke where the guy had graduated, and it took 4 years to get the case up to the Supreme Court. And by the time they graduated, the court said, this case is moot, right? We don't have to decide it. But with Bakke, it was a different story because he didn't go somewhere else. He applied for medical school and was just basically waiting around. So his case was still valid. So that's the first thing you have to understand about the Bakke decision. The second thing to understand about the Bakke decision is there's no majority opinion. No single opinion garnered 5 votes. No one got 5 votes. So what are you supposed to do when no opinion gets 5 votes? Right? There's something called the Marks rule. M-A-R-K-S. This is not an official rule in the statute, but this is the rule of the court. That what the justices will generally do is look to the most narrow opinion. Right? Whichever justice had the most narrow opinion is the rule of the case. So the oddity of Bakke is even though no one joined Justice Powell's opinion, you have 4 on one side upholding the program, you have 4 on the other side striking it down. The single vote of Justice Powell was enough to be the effective holding of the case. This is what O'Connor recognized some years later. So it's a bizarre thing in the Supreme Court where you can have 4 going one way, 4 going the other way, and there's one guy in the middle, so to speak, and that's the holding of the case. So I want to focus primarily on Justice Powell's concurring opinion. Emily, what is Powell's argument here?
Well, he said that the special admissions program was basically unlawful, and he said that, well, he joined the opinion saying that race was permissible as one of several admission components.
Okay.
So you can't just award points based on race or ethnic background, but it can be part of the overall application.
Okay, very good. What Justice Powell holds is that race considered by itself in terms of a quota is unconstitutional, right? In other words, you can't have a program with X number of seats set aside for certain racial groups. That was actually fairly common practice back in the 1970s. That was basically what Kennedy meant by affirmative action. You literally set aside a certain number of seats for people of a certain race. Okay? But he did say that race can be considered as one of many factors, right? Now the question is, Ayami, why does Powell think that race be considered as one of many factors. What interest is the government achieving there? We always ask them, what is the government's interest there?
Well, they had a few. I understood that it was because to remedy past actions, but then after reading the rest, I was confused as to whether.
Well, I'm asking a much simpler question, right? Under Justice Powell's opinion, what is the interest the government can pursue when they use race? What are they trying to accomplish? Not all interests are of the same level. What sort of interest is the government trying to achieve here?
I'm trying to understand the question.
Let me ask the question a different way.
Yes.
Why would the government want to use race in admission process? Why would the university want to use race here?
To ensure there's equality throughout the.
What do you mean quality? Give me a little bit more. You're on the right track.
Well, to ensure that not only there's not going to be an equal number of race admitted, but to ensure that there's a favorable amount.
Why? But why does the school want this favorable amount, whatever that number is?
Well, they talked about different things in regards to how different races bring different experiences, and am I going the wrong way?
You're exactly on the right track.
Okay. How?
Keep going. You're on the right track. You'll get there.
Minorities, like, they bring different experiences regardless of the, and how the public is a diverse community, and they want to have.
So, is the government's end merely diversity? Is that what they're trying to achieve here?
No, it's not.
What are they trying to achieve? Finish it up. You're right. You already said it.
A government interest?
What is the government's interest? To be very precise. It's not diversity by itself. What is it?
No, it's. I know my notes say the government interest is narrowly tailored.
We'll get to narrow tailoring in a few minutes. We're not there yet. I'm taking this one step at a time.
Okay. Well, they want to. They have a government program.
And what are they trying to? Why are they trying to use race? What are they trying to accomplish? You already said it. You gave me the answer.
No, where are you going with this? Are you moving on?
Yeah, do you want me to move on? I want to stay. I can move on. I can stay if you want. Your call.
No, I feel like I have it, but I don't know where you want to
John?
with it.
I think they're interested in educational benefits.
The educational benefits of diversity. You said it, right?
Oh, okay.
The test that Powell puts forward is you can use race when you're trying to secure the educational benefits of diversity. And I think Adiyami already said the answer, just to get the label, right? The educational benefits of diversity, by having people from different walks of life in your classroom, it brings different things to the learning experience, right? So, one of the biggest mistakes I see students make in the exam and otherwise is they say, aha, the government's interest is diversity, period, end of sentence. And that's not the holding, right? Merely seeking diversity is racial balance and having, let's have this number of white people and this number of black people have this great, no. It's the benefits, the educational benefits that flow from diversity. That is the government's interest that can be obtained, right? That's the interest the government seeks. So if you look at the Fisher case and you look at the Michigan case, they say the same thing. Emily?
Can you have a holding if there's a plurality?
No, and that's why I mentioned what's called the Marx rule, right? Under the Marx rule, you try to find a holding, but it's not a holding until 5 justices endorse it. So it wasn't until O'Connor, in the Michigan case, that she endorsed this Powell opinion that it became holding. So for 25 years, there wasn't a clear ruling one way or the other. So Lacey, so we start now from the premise that the benefits from education are a legitimate government interest, right? What can the government do to achieve that interest? How can the government actually go about achieving that interest?
By enforcing equal protection.
Well, they're always bound by equal protection, but how can the government go about achieving it? What are they allowed to do?
Affirmative action.
In what form?
Oh, like when they select races.
Hi. What's your name, sweetie? Alexis, hi. She told me she was coming. I knew it. She's a potential admit for the class of 2035. How old is she?
She's 6.
6. Okay, she's really in 20 years. Okay, perfect. So back on Lacey.
Yeah.
Not that easy. So, what restraints exist on the government being able to achieve this interest of diversity benefits? What can they not do?
They don't want to exclude the people who are already being benefited.
I'm not sure what you mean.
Like, I guess, like the white people are like more known to be not racially discriminated, and so with them opening or like limit.
I think you're on the right track. Rachel, what restraints exist on the government's ability to achieve these compelling benefits, this benefit diversity?
So you can't favor one group for like no other reason other than race or ethnic origin.
Why not?
Because that's just I don't know. It's purely discrimination. There's no other merits.
Let me try this. So I'm going to give you the test for strict scrutiny, right? You're going to have to memorize this, but for now, right up here. The test for strict scrutiny is whether the government program is narrowly tailored to serve a compelling governmental interest. Whether the government program is narrowly tailored to serve compelling governmental interest. You can see it different ways. This one's good enough for you for now. Crystal alluded to this a few minutes ago. All right, Jesse will pass over our. I think she has her headphones on. She's watching my last year's lecture, I'm sure. No, really?
Yeah, in the car.
What a smart girl. Good for her. Okay, Jesse, I'll just go to you, okay? In this case, right, with affirmative action, what is the government's interest? We said it a minute ago. Exactly. Just say it like that. They're the benefits that flow from diversity, right? Is that interest compelling here? What does the court say? Or at least Powell, I should say. It's not the court. What does Powell say?
Yes, but it can't be, it can be sold.
Okay, that's my next question, right? So we start by saying that that the benefits that flow from diversity is a compelling governmental interest, right? Unless you have a compelling governmental interest, you're done. In other words, you can't have a racial classification unless you're pursuing a compelling governmental interest. Go back to Korematsu, right? What was compelling governmental interest there? National security. That's what they said justified the exclusion of Japanese Americans. All right, Jessica, now I'll come back to you. What's this business of narrow tailoring? What does that mean?
It has to be a good fit.
What a great word. What does it mean, a good fit? Give me a little bit more, please. Okay, Daniel, how about you now? What's the risk, Daniel, when using a racial classification, right? Why is that potentially problematic? Why is it potentially problematic when you're making racial classifications? Yeah. Why is that problematic?
Your goal is diversity. You're assuming that they all have diversity of opinions they might not.
Yeah, so let me say a little bit different. I think I see where it's going with this. When you generalize people based on race, you're engaging in stereotypes, right? Maybe good, maybe bad stereotypes, but the stereotype. But there's another problem, Elizabeth, when you're having racial classification. What's the other problem? Beyond the stereotype issue, why is a racial classification really problematic?
In this case, because it's unfair when some people could compete for some
So who's complaining about this case? Who brought this lawsuit?
the white student.
Bakke, right? The white student was denied admission, right? When you use a racial classification, one side benefits, the other doesn't. There might be other prevailing interests. But Bakke here complained, saying, look, I was denied entry because of my race. So the courts are very skeptical when race is used. And what strict scrutiny says is, you can only use race in a very narrow set of circumstances, right? You can only use it when it's narrowly tailored, that your means fit your ends. And if you're trying to achieve the benefits that flow from diversity, you can't just use a straight up quota, because that's too broad, right? You use race in too big of a way. You have to use race in a more subtle way. And Zach, what's the way that they use race here? How does Powell hold it? Yeah, it's a factor of a factor of a factor, right? Race has to be one of many factors. And under these circumstances, Powell says that strict scrutiny is satisfied, right? It's narrowly tailored, that you're not just having a straight up quota, race is one of many factors. Martin.
So I'm having some cognitive dissonance with
Cognitive dissonance?
with the strict scrutiny.
In my class, there's no dissonance, only substance.
So
I like that. Cognitive substance, when you feed your brain, I like that actually.
when we look at Korematsu and we see that strict scrutiny was applied because national security was our interest, are we then saying like, oh, that was totally chill because strict scrutiny was applied?
Well, David mentioned Korematsu a few minutes ago, and I said, we cite Korematsu. And there's a sentiment that you just don't cite it, that this is the anti-canon, and we just never mention it. But let's take it for what it is. Korematsu basically articulated strict scrutiny and said this satisfies strict scrutiny, right? They said that the need to exclude the Japanese people was so great, it survives. But was the classification Korematsu narrowly tailored? We discussed options, right? Maybe have a loyalty oath, right? You can do other things to perhaps weed out unloyal people. This was a blanket ban. If you have any Japanese blood, report to this camp now. So even under the strict scrutiny standard articulated here, I don't think Korematsu survives, right? That is the Japanese intention. But Powell says because educational benefits are so important, that justifies use of race. But this is just begging a question, right, Martin? What's the big difference between Korematsu and Bakke? There's a really, obvious difference. It's so obvious you don't even think about it. What's the big difference between Korematsu and Bakke?
Internment?
Yeah, well, one case involves internment, this involves what?
Education?
Yeah. Okay, so right. So one case is using race to lock people up in camps, and the other one is using race to admit people to university. One is facially hurting people by locking them up in camp. This is helping other people by giving them admission to university, right? Mm-hmm. Now, is that a difference worth making? You mentioned Thomas, does not make that difference. It does not draw the distinction. But in any event, we generally don't cite Korematsu, but Martin's point is on point. His point's on point. Cognitive dissonance aside, betwixt the two cases, Korematsu and Bakke, you do have the question of does it survive strict scrutiny? Sorry, I can't help it. I really can't. Yeah, I can't help it. Okay. So, everyone okay with Powell, right? Yeah, Mark.
Can you actually explain that? So we don't typically refer to Korematsu because it's anti-canon.
I don't actually buy that, but it's in the book.
So
not that my name's on
again,
it.
what does that mean?
Okay. This is a place where I somewhat disagree with my co-author, but there are certain cases that are deemed so evil we can't cite them.
Gotcha.
And they're products of just absolute lunacy. And to cite them is to give credit. So Dred Scott, for example, right? You wouldn't want to write in a brief Dred Scott. You wouldn't want to write in a brief Korematsu citing it. You just wouldn't do it because the judge will laugh at you. But even though these are like anti-canon, they're outside the canon of cases we should study, they're important to understand because of development. And the strict scrutiny doctrine began with Korematsu. The court said, here's this standard which you should apply. They say we should strictly scrutinize these classifications. Oh, but by the way, it satisfies it, right? The other case that's considered anti-canon is Lochner. God forbid you cite Lochner. Meanwhile, almost all these cases from the 1960s and 70s involving abortion and birth control are all substantive due process cases. So I'm not a big fan of the canon anti-canon label. Randy loves it, but I abide, I suppose. David?
When did that become, when did it become anti-canon? Because this is 78, and Justice Powell cited Korematsu.
Didn't he? Yeah. I think it's something law professors make up. I don't know which way law professors think. Good reason. They tend to all think alike and they reinforce their own beliefs. So if it's cited by the court, look, you'll read Roe v. Wade in a week or two. That cites Buck v. Bell favorably, right? I'll put Buck v. Bell in the anti-canon any day, but it was cited favorably. So look to what judges do, not law professors, who are in much better stead. If the world was governed by law professors, we'd all be in trouble. Never mind. So other questions on Powell. I briefly want to touch on Justice Marshall's dissent. I think, Anthony, you're next. What's Marshall saying here? And the reason why I want to do this is in our next edition, the Marshall dissent got cut out, which I'm actually annoyed at. I wanted to keep it, but decision. So what's Marshall saying there, Anthony?
He was betwixt.
He was betwixt. Oh man, it's catching on. I love it. Thank you. Get a gold star for that one. He was betwixt. Betwixt what? Now finish your damn sentence.
He agreed with the judgment that,
Good.
but he did not agree that the admissions program violated the Constitution.
Okay.
The state should have a remedy for the past discrimination.
Very good. Very good. Thank you so much. So Justice Marshall, I think, articulates the most honest opinion in this entire reading for today, right? And I say honest very deliberately. All these other arguments about diversity and this other stuff, that's not the reason why affirmative action, right? It's not. It isn't. There's a speech I want to read for you on that entire thing. But President Johnson gave a speech at Howard University in the 1960s. It was a commencement speech. And I want to just read a part to you. He said, freedom is not enough. You do not wipe away the scars of more than a century by saying, now you are free to go where you want and do as you desire and choose the leaders you please. You do not take a person who, for years, has been hobbled by chains and liberate him. Bring him up to the starting line of a race and say, you are free to compete with all the others, and still justly believe that you have been completely fair. This is more or less what Marshall's getting at, right? You had hundreds and hundreds of years of oppression. Hundreds of years, right? And, you know, you had a Civil War, you had 14th Amendment ratified, you had Plessy, 100-something years, you had Brown, right? You eventually get to the Civil Rights Act, and it's like, okay, go, run your race. So what Marshall's saying is, let's just be candid here. The justification for affirmative action is to redress past grievances, to redress past unfairnesses, right? I mean, that's his explanation. I think it's very candid. And he's like, we don't need to get into this entire discussion of diversity because it's secondary. Now, Case, though, what's a problem with the Marshall rationale and why maybe the court doesn't want to lump onto it? Why might there be hesitancy? Even O'Connor doesn't reach that far. What are some potential difficulties with the Marshall rationale?
That it's discrimination.
What do you mean?
Well, I mean, he's clearly just saying that discrimination against to make up for the wrongs.
But how is Powell any different? Powell allows the same.
Powell allows it as a factor. He's just completely saying, you know, it's fine.
Yeah, but Carlo, what's the difficulty if we adopt Marshall's rationale? Does this rationale work forever?
No, I don't believe so.
How come?
Well, because eventually you're going to get to a point where things are getting more to equilibrium, I guess.
Right. So one of the reasons why the Marshall rationale, I think, has never quite caught on is by its own terms has an expiration date. Or does it? Maybe it doesn't, right? The argument is if we've had this much years of, you know, oppression, then we need this now. What Marshall is basically saying is this is like a temporary measure, right? It needs to get basically to equivalency. In contrast, the diversity rationale doesn't, because there will always be benefits of diversity, now and forevermore. Even so, if you notice O'Connor's opinion, she puts that 25-year clock. You ever notice that part, right? Now, she didn't actually mean 25 years. There was actually a funny exchange during the Fisher arguments, where one of the lawyers said to, I think it was Scalia, said, so, coming up in 25 years, and the lawyer said, I don't think that's what you meant. He's like, I know, we did it. So, that part isn't, I think, meant to be taken seriously. But what the Marshall dissent is saying is, let's just be candid about the reason why we're doing it. But Marshall lost, and we've never had a Supreme Court decision saying that making up for past discrimination in education justifies future discrimination, future racial classifications. Mark?
So Powell actually addresses that and says that the medical schools perceived as victims of societal discrimination does not justify a classification that imposes disadvantages upon persons like the respondent who bear no responsibility for whatever harm the beneficiaries of the special admissions programs are thought to have suffered.
Right. I mean, the argument is, did Alan Bakke do anything to enslave people, right? Or does he merely benefit from the fact that there was slavery? There's also basically an element of guilt, right? Why are we suffering from this? Or, say it differently, Michigan had no history of racial discrimination, whereas Texas did. Do those cases now come out differently, right? Does the fact that Texas had a history of exclusion of people based on race, and Michigan just didn't? It wasn't in the state's history. Okay. The other dissent by Berger, Stevens, and Rehnquist, and was it White? I'm trying to blank the other one. It focuses on the statute, and I don't want to care much about that, except to say that there were, in the end, 5 votes to invalidate the UC admission policy, but there were still adequate votes to allow other types of affirmative action to proceed. Okay. Questions on Bakke? We moved that a little bit quickly. We have a lot of cases for today. An hour, it wasn't very quick. But it's a very important case. I'm very sad we had to cut out the Marshall dissent. I think it's a good read, but space controls. You have to put both fissures in. You call it a fissure in the reading. There it is. Mark?
Unrelated, what's the buzz within the ConLaw circle around this movie?
On what movie? Oh, the Marshall movie.
Yeah.
Has anyone seen it? You saw it?
Yeah.
What'd you think?
I thought they portrayed him as a superhero.
A superhero? That's actually not that far from the truth. What? I mean, did you like it? I mean, was it from a lawyer's? I guess from a first lawsuit, right? Was it a credible legal story?
I didn't know the case all too well, or at all really.
Okay.
But it seemed okay.
Okay. Anyone else seen the movie? I haven't seen it yet. I was hoping it had some Supreme Court stuff in there, but it's not. It was about a trial. Was it a rape trial? Was it a murder trial? I can't remember what it was. So basically, was it a black guy accused of raping a white one? Was that? I think that was I can predict the outcome of that one. I won't ruin the ending for you, but the reviews are good. I haven't seen it yet. My general rule is that court movies are terrible because they screw things up. But hopefully, did it follow procedure as it usually would in trial?
I don't think he'd like it. It didn't seem like it followed procedure or anything like that.
Yeah, you don't want to go to a court movie with him. I'm going to ruin it for you. I always make a scene. It's bad. Yeah.
Along that lines, you see the movie Bridge of Spies?
I did.
How was that, terrible?
Don't ask me that movie. I was so excited because of the Supreme Court. So I will give it. They accurately conveyed what the Supreme Court looks like. So they built a set. That was Tom Hanks, right? Mm-hmm. Yeah. I blogged about that one. I have a post on it somewhere. So the set was okay, but the court drama was all fakaked. That's fakaked. It's a Yiddish word, not what you probably thought I said.
I got you.
Yeah, Adam got me. Okay. Yeah, but Marshall basically was a superhero. I mean, the sorts of cases he handled were just remarkable. He would go into these towns where, he could have gotten lynched at any moment. Just killed, on the street. There's a level of bravery there. In fact, by many accounts, Thurgood Marshall the lawyer was greater than Thurgood Marshall the justice. His career on the bench, I mean, not to diminish it, but actually pales in comparison to what he accomplished as a private lawyer, which is hard to imagine, but it is such. So I'll watch the movie. I guess on Google Play eventually. I don't go to theaters. Start yelling at the screen, it'll be bad. I'll ruin it for everyone else. That's why I don't want to do it. I'll watch it on my tablet. All right, other questions on Bakke? Kevin, Bruder, give me the facts, please.
So with Bruder, she was applying to a law school in Michigan's law school.
Good.
She was quite intelligent. She had a 3.0.
Well, she had good grades. Don't pretend having good grades makes you intelligent. They are not. Trust me, they are not the same thing.
She had very
She
good grades.
very good grades. We'll leave it at that, right? Her grades are good.
Yeah, 3.8 GPA. LSAT was 161. But this law school denied her, and one of the reasons they denied her was because of her race. They put a lot of emphasis, not a lot, but they put emphasis on race and how it plays into a factor. I think there was a study also done by Dr. Stephen, I can't pronounce his last name, who took all the emissions during that time and he put them on scale to see where they would fall. And he said that race did play a big cause into this, and if it was a race blind emissions, that it would have a dramatic impact on the emission process.
Okay, very good. So the backdrop of this case is decided 25 years after Bakke. And again, the Bakke case, there was no majority opinion. There was only the plurality. So a lot of people had simply assumed that Justice Powell's opinion would be controlling, but it hadn't been established. And the backdrop of this case, which is important to remember, is there was a very strong sense that the court would rule 5-4 that all affirmative action policies were unconstitutional. There was a very strong fear. In fact, one of the most influential briefs ever filed in the Supreme Court came in this case. It was a brief filed by former generals, right? And what the general said is, unless we have affirmative action, we can't fill the military and the military service academies with diverse classes. We won't be able to do it. And this brief, we believe reports, was very influential in the court, right? So, David, oh, that's right, David, thank you. David, what does O'Connor do here? What's O'Connor's, how does she read Bakke?
I mean, she looks at kind of what the school is.
No, let's start the precedent. How does she read Bakke? Bakke was a case with no majority opinion. How does she read Bakke?
Well, she looks at Justice Powell's opinion,
Good.
and she says Justice Powell's view about government decisions touching upon an individual's race or ethnic background is entitled to judicial determination. That the burden is asked to bear on that basis is precisely tailored to serve a compelling governmental issue.
Very good. So O'Connor looks to Powell, even though he was only one instead of four, as the holding, right? And so Kevin, what is the compelling governmental interest that O'Connor identifies that courts can pursue?
That it's based
Oh, I'm sorry, David. I said the wrong name. You're right.
Go ahead and take it.
No. David's still on call.
Say the question.
What is the compelling governmental interest that O'Connor identifies that can pursue here?
The attainment of a diverse student body.
Well, not just the attainment of diverse student bodies. Specifically, what is the benefit?
The nation's future
A little more precise.
depends upon leaders trained through wide exposure to the ideas and morals of students.
How do we? You give me examples, but what's the category we use here? What exactly is compelling governmental interest here?
I mean, to advance education or to have not a diverse student body.
Well, it's not diverse student body by itself, Evan.
Then they want to just, was tricky, they wanted to admit a diverse student body so that they can, well, it was just the equalized playing field was to break down the barriers of race.
it was that having this diverse educational environment would strengthen the educational environment.
Yes. The benefits that come from diversity, right? It's not merely having a diverse student body by itself, right? What they're seeking to achieve are the benefits that flow from that diversity. And I think David, I think Evan, you mentioned a couple examples, right? You break down barriers in classrooms, you teach leadership skills, right? You give people different walks of life. You can walk through all these benefits. But O'Connor's opinion is premised on this fairly narrow but pretty broad understanding that the benefits that flow from having diverse classes is compelling, right? So that's not problematic, right? That's more or less an application of Bakke. Martin, is your hand up?
Yeah, I'm still hung up on the military thing. Why couldn't they fill their ranks?
And the military academy, the service academy at West Point.
Right. Why couldn't they? Why would affirmative action be the only thing that allows minorities into their schools?
Well, ask yourself the same about the University of Michigan, right? Why did the University of Michigan say they needed affirmative action? The answer is exactly the same. In other words, if the school had an admission platform based exclusively on GPA and LSAT, why would Michigan Law School not be able to have a sufficiently diverse class?
There's a disproportionate number of white people with higher GPAs and that sort of thing.
Yeah. If it was based strictly on, and look at the studies of this doctor, right? If they based it strictly on GPA and LSAT, they wouldn't be able to achieve enough people to meet their standards. Yep.
So this only applies to public universities?
Well, did you read Rehnquist's concurring opinion in Bakke? Or was it Berger? What did Berger say there?
That they receive in federal funding.
Yeah. So here's the dirty little secret, which most people will never even know. The 14th Amendment only applies to state action. But every school in the country, except for like one or two, accepts federal money. And all schools that accept federal money are prohibited from discriminating on the basis of race. There's a lawsuit pending now against Harvard. If you think Michigan's affirmative action policy is a little wacky, at Harvard, it's basically blatant quotas, right? There's no way to explain it. But Harvard says, aha, we're not bound by the 14th Amendment. Yeah, but they accept federal money. And there's a lawsuit now challenging Harvard's admission policy, which basically, like, you get to the Asian question later in Fisher, but like, it suppresses Asian admissions by a factor of a lot. So, Kevin, to answer your question, yes, only public schools are bound by the 14th Amendment, but private schools are bound as well by this statute, as are public schools. Unless the court's composition changes, I don't see this going anywhere, but that Harvard case is floating.
So basically, we can take federal
It's actually, this is Josh speaking now. I'm always speaking, this is my opinion. I think the statute is actually more strict than the 14th Amendment. I think the statute makes racial classification prohibited, period. At least with the 14th Amendment, you have some balancing, right? The statute, I think, is a blanket. Anyway, where was I? So we know that our, let's go back to our notes for the day. We know that our compelling interests are the benefits that flow from diversity, right? Okay. So Amber, how does the court approach the narrow tailoring question here? At least in the Michigan Law School case.
Well, they say that in narrowly tailored, a race-conscious admission program cannot support a system. So basically, they just want to make sure that you're not doing, you're not specifically focusing on only race. They want you to focus on race as well as everything that comes with the differences of race.
So Amber, let me ask you a follow-up question, please. Why does the court uphold the law school's admission program, but strike down the undergraduate admission program? There are two parts, right? The undergraduate's invalidated, but the law school's upheld. Why did the court split the difference here?
Well, compared to the Harvard thing from Bakke, which was that it had multiple different factors, including like a personal statement, recommendations, everything. So it wasn't specific to race, unlike in the undergraduate program, where it was specific towards a quota for race.
Right. So the undergraduate program was different. With the undergraduate program, merely being a certain race added points to your total score, right? it wasn't considered as a factor. It was saying, if you're this race, you add 20, 30 points, whatever it is. But David, what's the difference, right? What's the difference whether it's an explicit addition of 20 points or, well, we're going to consider it one of many factors, wink, wink, nod, nod, what's going on here?
Other than the wink, wink, nod, nod kind of being semantically different, but I mean, assigning points to a person, I mean, gets to that where you're actually excluding somebody by not putting them on the same
Well,
level.
Barbara Gruder, she had a 161 LSAT, 3.8 GPA. She was being excluded, wasn't she? So this is actually just as Ginsburg's point, right? What Ginsburg basically says, this is all a waste of time. It doesn't really matter what you tell an admissions officer, they'll figure a way of getting what they want. Right? They'll figure a way of making it one of 15,000 factors, but one factor matters more than others. And they don't need to have an explicit point system to get there. It's also Alito's point in the Fisher case as well. So the court says, okay, the compelling governmental interest benefits from diversity. Is it narrowly tailored? Yes, we're only using race as one of many factors. Okay? Now, Aaron, here comes the $1 million question. How much diversity is needed to achieve those benefits? Right? How do you know if you have enough, right? 14%, 15%, whatever the number is, right? How do you know when you have enough benefit to achieve those diversities?
I don't think you do, but they use the term like critical mass.
Oh, that's exactly what I'm looking for. Critical mass, right? What is this phrase, critical mass? What does that mean? Yeah, I'm asking. No, I'm asking Alexis, right? I'm doing that, man. It's like most of my students at the end of
I don't think it really means anything personally, but
what does, just given the words critical mass, what does that, in the abstract, what does that mean?
yes, it's that point at which, you achieve diversity.
Right, so Jackson, is there a specific number of what a critical mass is?
No.
Why can't there be a specific number? What would be problematic about that?
I guess we could just keep going on forever.
I'm sorry, David, raise your hand, please.
Yeah, it's a quota.
The quota. Right, so here's the dilemma with they give a critical mass. Once you give a number, let's say 15%, whatever, 20% minority, then you have a quota that's unconstitutional. So the difficulty for the universities in both the Michigan cases and the Texas cases is this dance around what critical mass means. It's basically, we know it when we see it, right? We know it's going to happen when we get there. We can't tell you about it. But when we get there, by golly, we'll tell you. Does anyone believe that? Of course not, right? It's affirmative action today, affirmative action tomorrow, affirmative action forever, right? So reverse George Wallace. They will use this as long as they want to. And they won't tell you when it's gone. But the court here defers to that determination. What do I mean they defer? What O'Connor says is it's not for the courts to say when that critical mass is reached. We will give that sort of deference to the educational institutions. Right? So as a result, the compelling interest is getting the benefits of diversity. They can keep using it until they hit a critical mass. They won't tell you what that is, but as long as race is one of many factors, it's upheld. And therefore, the classification survives strict scrutiny.
So how does that critical mass end with quotas?
Well, let's say they said the critical mass is 20% of our student body is minority. That'd be a number, and that'd be a quota. Right, so they can't give a number. This idea of a critical mass, like, you need enough so it works. How much of it is going to tell you? And you notice this in the Fisher case, it did surveys saying, we noticed in certain classrooms there were certain classes with 0 minorities in the classroom, right? So they can calculate the number, but they just don't tell you what number they're looking for. One number that's often used is, let the percentage of, say, African Americans and Hispanics in university mirror the statewide average. Right, that would be one number. But again, that's a quota. Right? So let's say, I don't know, in Texas, 40% Hispanic, whatever the number happens to be. Okay, then university has to be 40% Hispanic. That'd be a quota at the end. So you can't do that. That's the wink, wink, nod, nod part. So So any more questions on the majority opinion, right? O'Connor adopts Powell to show the benefits of diversity as a compelling interest, and using race as one of many factors is considered narrow tailoring to get to this critical mass. So any questions to the majority? Okay, any questions? So Alyssa, what's Justice Thomas's? Justice Thomas is a very unique position here. What's his?
Again, there's no majority there, right?
Oh, there is. Yeah, you have O'Connor, you have Stevens, you have Ginsburg, you have Dreyer, you have 5. And Souter, I always forget Souter. You got 5, yeah. This was 5-4. Right, it was 5-4 in Grutter, but it was 6-3 in Gratz. I'm sorry, but it was 5-4 the other way in Gratz. So it's 5-4 upholding the policy in the law school, and 5-4 the other way in Gratz. Basically, O'Connor just flipped sides. Anyway, let's go on to Justice Thomas. What's Thomas's argument here?
Well, he brings up Frederick Douglass's quote saying just leave pretty much race alone when it comes to discrimination. Like, don't even try to remedy our societies and states.
Yeah, did that Frederick Douglass quote stand out to you when you're reading your paper? Yeah, so I've mentioned Frederick Douglass a couple points this semester. He was a very prominent abolitionist. He was a freed slave. He had an amazing story. But he took a somewhat unique position on race. Thomas actually has a bust of Frederick Douglass in his chambers. And the summary of this position is, I'll read the quote, "If the Negro cannot stand on his own legs, let him fall. All I ask is give him a chance to stand on his own legs. Let him alone. Your interference is doing him positive injury." And this summarizes, I think, quite succinctly Thomas's position on race. He himself was the beneficiary of affirmative action. He was admitted to the Yale Law School on their affirmative action plan, and he resented it. And he wrote an entire book on it, which you should look at. And he describes how he felt his degree was devalued. In fact, for years, he wouldn't even go to Yale. He wouldn't even hire Yale law clerks for the longest time. He eventually had an arrangement. He put a sticker from a cigar box on side of his diploma for like 15 cents, and this is what this diploma is worth. So he felt betrayed by this, that he was devalued, because people said, you only got in because of this program. But taking a very different position is Justice Sotomayor, who also went to Yale Law School a couple of years after Thomas did. And she was admitted by an affirmative action plan. She's proud of it. She's like, this gave me an opportunity I could have never otherwise had. So you have in the Supreme Court 2 people who have reached the pinnacle of their profession, very tip top, who went to the same law school at roughly the same year, admitted under similar circumstances, going completely different ways. And I think this manifests how they approach affirmative action.
Sotomayor is I'm Puerto Rican, so she's like my idol. And a lot of it, aside from your statement, a lot of her book states that one of the reasons that she was so proud of the affirmative action program is because it also allowed a sense of familiarity and to really understand the culture outside of the island with those that have migrated to the United States. And I think even now today, affirmative action is a real issue within people going into school and how they feel about it, or how they're often degraded because they've entered school through affirmative action. The application. Just an opinion.
Okay, thank you. Yeah, so if you want to read both Thomas's book, My Grandfather's Son, and Sotomayor's book called My Beloved World, very, very different takes, but I encourage you to have some summer reading. They're both well worth the read. Okay? So that's Thomas's opinion. He would repeat this thing, as Martin said, several times over the number of years. But the second point of Thomas that I want to stress on is this actually strict scrutiny, right? Is this actually applying strict scrutiny? And I go back to the question I began at the beginning of class, right? Generally, when the government makes a racial classification, it's presumptively legal. It's presumptively legal. There's this expression that strict scrutiny is strict in theory and fatal in fact. And generally, once you apply strict scrutiny, the law is void. But here the court gives a lot of deference to the government, the university in this case, to uphold this. And Tom is saying this is not how we do strict scrutiny.
I'm sorry, I couldn't hear. Did you say presumptively legal or illegal?
Illegal. Right, when you have a racial classification, it's presumptively void. Right, generally it's like if you want to group people based on race, yeah, good luck, get a lawyer, right? You're probably gonna lose. But here what Thomas is saying is this is not strict scrutiny. Thomas would basically say it's illegal today, it's illegal in 25 years. The Constitution means the same things it does in 300 months, right? The meaning of the Constitution doesn't change on the basis of what point of history you are. Now, there's one argument against Thomas that he's never quite addressed, which always irks me. It doesn't mean he's wrong, but there's one argument that's always bothered me, is that there was a lot of evidence that at the time of the Reconstruction period that the Congress used race-conscious measures, right? As you read the Freedmen's Bureau Act, which is always at the end of your reading. And there's strong evidence that when the slaves were freed, the government said, we are giving certain benefits only to the freedmen, which basically meant only people of African descent. So if the very Congress that ratified the 14th Amendment was using race-based measures, is it insane to think that perhaps those measures can be used today in universities? Now, I think what Thomas would reply to that is, perhaps those were appropriate in the 1800s after the Civil War, but they're no longer appropriate today. But that does rebut the argument that it's always prohibited no matter what. So there's an argument here that Thomas, I'm still waiting for him to address. Maybe he will. I blogged about it. Maybe he'll read my blog and respond. I don't know. But it's an argument that's floating there. Martin.
So, because the 14th only applies to states, private corporations are exempt from it, and so we can't prevent them from racially discriminating with the 14th, so we use the Commerce Clause.
Use a Commerce Clause for the Spending Clause, right? Private universities like Harvard, not a state school, it accepts federal money. And with that comes certain strings, which include prohibitions on racial discrimination.
Well, what if you had something that didn't accept federal money?
A college that didn't?
Yeah.
There's only one, Hillsdale. It's a small college in Michigan that deliberately takes zero federal money to avoid those mandates. So basically all of them do. And when I say federal money, if you're a student that takes federal loans, right, that's federal money, right? If you're paying your tuition with a federal loan.
So Hillsdale is
basically the only one.
Totally fine.
And they take no student loans, they have to pay cash or private loans.
But they're fine to discriminate based on race, constitutionally.
Constitutionally, yes. There are certain other statutes that prohibit racial discrimination, but that's different from whether they can use affirmative action or not, right? There are certain laws that you can't exclude people from places of public accommodation. That's Hearts of Atlanta Motel. That still applies to the Commerce Clause. But the specific law I'm talking about here concerns admission policies, right? So any other questions on Thomas's dissent in the Michigan case? Let's see. All right, so that's Grutter. Gratz I'll mention much more briefly, only because it's basically decided because of what O'Connor did in the other case. In Gratz, it wasn't holistic. What do I mean by holistic? Using all these factors floating together in this stew of admission policy, right? With the undergraduate admission policy, it was very blunt. There were a total of 150 points. If you got 100 points, you were admitted. If you were a member of a certain minority group, you got 20 points. All right, so basically you got a fifth of the way to admission merely by membership in these various groups. And that was generally worth about more than a perfect SAT score. The court said that this this automatic factor was not narrowly tailored. That is, they were trying to achieve the same governmental interest, benefits of diversity, but it was not narrowly tailored because it was so mechanical. And as a result, the court struck down the undergraduate policy. Now, that's not the hard part, right? What am I up to now? Portland. So let's say you were a college admissions officer in Michigan, right? And you just learned that the law school's policy was upheld and the undergraduate one was struck down, right? You're a smart guy. What do you do?
The undergrad was struck down.
The undergrad was struck down, but the law school was upheld, right? What do you do here?
Just get rid of the Floyd system,
Yeah, and adopt what?
the system that the law school uses.
Yeah. So the consequence of these two cases is all the law schools, all the colleges, okay, we will do exactly what the law school did. Now, what does Justice Ginsburg say about this, Mark? Ginsburg, I think, has a very brutal, honest dissent here. What's her point?
My takeaway from her dissent, I'm not a fan of hers, to be very honest with you, was that the stain of generations of racial oppression continues to exist, and that needs to be taken under consideration when creating such policies. Okay,
but what's Ginsburg's other point? She says, one of my favorite lines, if honesty is the best policy, right? What is she getting at here? What are colleges actually going to do here?
They're just going to play the system.
Yeah. She says, let me read her quote. She says, one can reasonably anticipate that colleges will seek to maintain their minority enrollment, whether or not they can do so in full candor. In other words, they will achieve similar numbers through winks, nods, and disguises. Mark, what's she getting at there?
Again, using a different means to achieve the same ends.
They're gonna camouflage what they're doing, right? They're gonna simply do exactly what they were doing before, and just call it something else. So whether they screwed up by giving race 20 automatic points, so instead they'll construct this elaborate spreadsheet where if you're in this box, and this box, and this box. So the bottom line, right? The bottom line of all these cases is the schools are going to do exactly what they're doing before, right? They're going to do exactly what they were doing before, with very little changes. They may just style it differently, have different training manuals. Even if the court had struck this down, they probably would continue doing what they were going to do. The schools weren't particularly interested in following the rules here. But that's Ginsburg's point. I think she's probably right. Emily.
So if the court, at least some dissenters, acknowledge that point, why don't they just defer to the universities? Like, why do they address it?
At all?
Well, I mean, I know why they address it, but it just seems like they're going to do whatever they're going to do anyways.
Well, then why don't we take the Thomas approach, say it's all unconstitutional, stop it. In other words, what O'Connor is doing here is saying, well, I think there's a way that this can be done lawfully, right? What the dissenters are saying is, give me a break, right? They're going to do what they're going to do anyway. The schools here are committed to this mission regardless. In fact, if you want to bring this to current events, the current Justice Department is actually looking to go after schools who are using these sorts of policies. The way to make them hurt is to cut federal funding. Crystal mentioned this a few minutes ago, I think. I fully expect in the next 3 to 7 years that schools with these sorts of policies will lose federal funding. That will change hearts and minds, not lawsuits. Crystal?
I didn't mention it, but I think you read my mind because I was thinking about it.
You said something about it. You said about whether it applies to the state or federal, didn't you?
I don't think so, but maybe it was
Weird. Okay, well, I read your mind. I'm sorry.
It's okay, but
I thought it was you. Who was it? Someone said it. Take credit. Yeah.
But it seems a bit, do you know when the federal government started giving aid to schools who took
A long time ago.
It was a long time ago.
Maybe the last half century. I can give you a year off the top of my head.
Because it seems to me that giving federal funding is almost encouraging the schools to do these sorts of things regardless of how the court rules.
Yeah, which is why I legitimately think the way that this situation will be addressed is not by the Supreme Court, but by yanking funding. I do. All right, so any other questions on the Michigan cases before we go into Texas?
I'm kind of curious. So the whole 20-point allocation thing is the problem with it. Both are mentioned that there's a mechanical, oh, you're a minority here points, or is it the gravity of the points that are received? Because they'd mentioned if you were a musical virtuoso,
5, yeah.
you get 5 points.
I think it's both. I think the fact that it's automatic makes it like very jarring that you're just lumping people in, and the fact that such a disproportionate share is also problematic. Right, but even the law school's policy, which didn't have the automatic bump, depending which race you were, it could be out determinative. Like you're also like 5 or 6 points lower to still get it. Right, that's not to say that these are even good measures. And that's another point that Thomas raises, which he's mentioned several times. If the SAT is such a racist exam, why do you keep using it? Right? If it's such a poor measure of admissions, why do you keep using it? Mark, is your hand up or are you just stretching?
It is. I didn't want to interrupt you, though.
Please, for once, I appreciate it. You should have no problem with interrupting me.
This applies to corporations as well, right?
Well, this is a 14th Amendment case, so no.
Okay, because I used to work for a minority business enterprise, and it was owned by a guy who was able to tick the Latin American box because his mother was Brazilian, but his father was Caucasian, who had found his way to Brazil after World War II for reasons that probably you and I both know.
Right. Yeah.
So this guy...
so basically, he was a Nazi minority.
Right, and he was a fraud. But he was able to get through this minority business enterprise, and he became very, very successful. But and I was under the impression that companies like, Fortune 500 companies like Colgate-Palmolive were required to delegate a certain amount of revenue towards minority business enterprise.
They are.
So how does that factor in here?
Well, when private businesses are doing their thing, they can allocate business however they want, right? The question is, how can the government give certain tax benefits to minority-owned businesses? It's a very uncertain area of the law. It's consistent with Grutter, but not really. If you notice, Grutter was very much about higher education. It didn't involve high school, and there was another case decided in the 2000s involving affirmative action for high schools, and that case came out differently. Any other questions on the Michigan cases? All right, let's go to Texas. How many Longhorns we have here? All right, hook 'em, right? A couple. Usually there are a few. So by way of background, in the mid-1990s, I think in 95 or 96, there was a decision from the Fifth Circuit called Hopwood. And the Hopwood decision ruled that the University of Texas could not use any sort of affirmative action, right? This was after Bakke, but before Grutter. And the Fifth Circuit ruled that this was unconstitutional. It was appealed to the Supreme Court. The court did not take it. So in response to this decision, UT was barred from using any sort of racial preferences. So they instituted what became known as a top 10% plan, which is actually not even 10%. Was it now 7 now? I think it varies year by year. Was it 6 or 7?
It's pretty tough, whatever it is.
Whatever the number is. So it was originally top 10%. And as stated, if you were the top X percent of your class, you were guaranteed admission to any public school in Texas Georgia. Now, God bless the Aggies, but this was primarily about UT, right? I suppose you can be the top 10% and go to A&M, but this was about getting people to UT. Now, why was this policy enacted? Chris, are you next?
Yes, I am.
Why do you think this top 10% policy was enacted?
I believe it was to help with the whole race and discrimination issue.
How would guaranteeing the admission of top 10% of your class allow more racial minorities into UT? It's neutral. It does nothing about race in the policy, right?
I think it's because it is neutral. Because the fact that if you
Is it neutral?
Well, if you're getting the grades, then yes. So if you're in the top, like, the school doesn't have any determination on who is in the top 10%.
Well, it's neutral in that sense. Marta, the composition of Texas public schools equally allocated by race?
No.
No. More.
Well, having been in Texas, I went to the school that was not the white school and was down the road from the school that was not the black school. Like that, we just still have segregated schools in Texas.
Okay, so this policy, this 10% plan, was designed specifically based on the idea that certain high schools were majority Hispanic certain high schools will be majority African American, and certain high schools will be majority white. That's just demographics. So by saying the top 10% of, say, Hispanic high schools, you're guaranteeing that probably most of them are going to be Hispanic. And the top 10% of an African American high school, you're pretty much guaranteed most will be African American. And then the top 10% of a white high school will be pretty much a bunch of white kids, right? That was the design of this program. It is not racially neutral. Let me say that again. The top 10% plan is not racially neutral. It was drawn up specifically premised on the fact that Texas high schools are de facto segregated, right? Not de jure, that it's not by law, but just as a matter of demographics where people live. So depending which high school you go to, if you're the top 10%. Now, again, being in the top 10% at, like, Sugar Land High School is probably different than being the top 10% of a school down the valley somewhere. It just is, based on class ranks. Abigail Fisher, I keep leaning on this thing and I keep breaking all the different classrooms. It's bad. They'll bill me for it one day. I'm like a locust that comes to every classroom and destroy it. So we have Abby here, Abigail Fisher. She was attending Sugar Land. Anyone from Sugar Land High School? No. She attended Sugar Land High School, which is a pretty well-to-do school, and she fell outside the 10% mark. Had she been at another school with her same credentials, she probably would have gotten into the 10%, but she fell outside at this Life High School. Does it still happen that people transfer to another school for the senior year? Does that happen? I've heard of this. People legit do this, and just to get into UT, is that the... Okay, well, people tell me this. I didn't have this when I grew up, but apparently it's a thing. She didn't get in. Applied to UT, declined. She went to LSU. She was not apparently very happy about that. Go Tigers. She sued. Okay? Now, here's actually a funny story people don't know. Originally, there were two plaintiffs. There were two people denied entry to UT. The other one, another girl, I can't remember her name, she dropped out of the case, right? Why? She went to SMU Law School. And while she was in law school, she did not want this case on her resume. So she actually dropped out of the case at a fairly late juncture. But Abby stuck around. Yes, Amber?
So when we were doing our declaration of intent and stuff, we had to put anything that was in a court system, right?
Oh, that's right. Yeah,
Would she have had to put that?
I think so. Yeah, you can imagine why she maybe didn't want this on her record. Like, hey, we're studying a case in the Supreme Court involving me, right? No one ever wants to be the subject of the cases, although I suppose it happens.
She can recuse herself from class.
She can recuse from class. I'm sorry, Professor, I can't be cold today. This is this case is too personal to me. Yeah, it's complicated. Anyway, so Abby brought the suit, and she asserted that the policy used by the University of Texas was unconstitutional. Marta, you next?
Probably.
Oh, no, Bahar, you next. I appreciate it. See, with a small class, you hold on twice. It's the damnedest thing. Bahar, how did the University of Texas's policy differ from the policy used at the University of Michigan? Or did it? Maybe it didn't. I don't know.
Well, with Michigan, they looked at other factors. Whereas this is just looking at one. It's looking at your percentage.
Well, that's the top 10%. I'm talking about their use of race separate from the top 10%. In other words, after Grutter, Texas said, let's do it. Let's use race again, right? How does UT use race?
Well, didn't they use it as a consideration?
They did. Emily, how was race used here?
It was a factor, but they put it on a grid.
Okay.
Like a holistic approach.
Does a grid sound very holistic?
I don't know.
What does holistic mean?
Like all-encompassing.
You just did it at the same time. It's very fun.
Did we?
Yeah.
Well,
Very good.
visual
But
learner.
does putting something in a spreadsheet sound very holistic?
No.
Of course not. What does it sound like?
Not holistic.
What in terms of the Michigan program, right? You have the one for law school and you have the one for the undergraduate, right? Which one does it sound like? Closer to?
The undergrad.
Yeah. this sounds a lot like the undergraduate program, right? Where you have a spreadsheet, and you have a grid, and then you put, you're in this cell, and you have this XY axis, and then, if you have this and this, and you match up. It sounds pretty mechanical, right? So, yes, it's true, race wasn't a single factor, but it was a really compelling factor, which the majority admits. Adiana, I think you're next. Yeah, this small class, we're going on pretty quick. What does Justice Kennedy do here? Fisher. By the way, this is Fisher Part 1, and we have Fisher 2, so I'll just call it Fisher 1 and Fisher 2 so you can distinguish it. What does Kennedy do here in Fisher 1?
I'm trying to open it up, it's so small. What does he do in regards to?
Do you have it? What's the whole thing in Fisher? What does Kennedy do here?
Well, so there's a big review of the relevant law in the area, and then
Okay.
we're vacated.
Well, I know it's vacated, but what does Kennedy say was the error below? Why did the lower court make a mistake here?
Oh.
You go back to it. Yeah.
Because they used the wrong,
Good.
standard, the scrutiny.
Adiana, I'll ask this follow-up question. Does Kennedy think that the Fifth Circuit used strict scrutiny?
I'm sorry?
Does Kennedy think the Fifth Circuit used strict scrutiny?
No.
Okay, good. Why not? Why does he think the Fifth Circuit did not apply strict scrutiny?
Sorry, I'm trying to, I rather make notes, I'm trying to think through it, I can make my notes on the computer.
John?
So it's not a deference thing?
Deference, right? What sort of deference did the Fifth Circuit give to the university?
Well, in the critical mass and what they required, and I guess assuming the ends were
right. So we talked before about, what is this critical mass, right? What is the specific standard of when we're going to meet this? Now, Lacey, in Grutter, did the court make the university define what the critical mass was?
Define as a definition? They kind of had a synopsis of it.
Did they make the university in Grutter articulate what the critical mass is?
Yes, I guess.
No. Rachel?
No, they didn't.
They didn't. So why would they have to do it here? In other words, they didn't have to define the critical mass in the Michigan case. Why should they have to do it here? I thought O'Connor said in Grutter they defer.
I think it was necessary here to determine if the policy was necessary to achieve the benefits of the diversity.
But they didn't have to do this in the Michigan case. Why do it here?
I don't know. It just seems to me like they were narrowing the
So,
scope.
Rachel, let me ask you this question. How did Justice Kennedy vote in Grutter?
In Grutter?
How did he vote in Grutter? You can flip back, that's fine. Who's on deck?
Kennedy was a part of the dissent.
Kennedy dissented. And where is Justice O'Connor in Fisher 1? Is she on this case?
I don't see her.
No, she's not. She retired.
Oh, she's gone.
She's gone. No, she's still alive. She's still with us, although she's not doing very well. Her health has been very bad the last year or so. She's not doing well at all. The biggest difference from from 2003 to 2015, or was it 14, is O'Connor was replaced by Alito, right? The 5 votes that were in the majority in Grutter, poof, gone. So now, Kennedy dissented in Grutter. Kennedy agreed with Rehnquist, saying that we can't defer, that we need to articulate a compelling interest with certainty. That's the difference, right? They weren't asking for Grutter to be overruled. Be very careful with that. The plaintiffs in Fisher were not asking to overrule Grutter. But the question of how to define the compelling interest is still fair game. So what happens here, right, in Fisher 1, is Kennedy says, look, we're going to just say that the Fifth Circuit did not apply the correct standard. Now, did you all read the little blurb I put between the two cases? This is why you want my book and not the other books. There's a lot of, I say it to myself, I had to fight to put this one in, but I think it works. There was a lot of stuff going on in the back seat. There was a book by Joan Biskupic, who's a very well-respected Supreme Court reporter. I recommend her books highly. According to her reports, the original vote in Fisher was something else. The original vote was to invalidate the UT program with Kennedy in the majority. But apparently, your goddess, Justice Sotomayor, circulated some sort of very blistering dissent, which said, how do you do this? And Kennedy said, okay, well, let's see if we can try to do something else, right? Let's just say remand it back to the Fifth Circuit and hope they take care of it, right? That way we don't have to do it. Let the Court of Appeals take care of it. Didn't work. Did not work. So the majority in Fisher 1 remanded it back and said, hey, once they remand, I think we send it back to the lower court. They sent it back to the Fifth Circuit saying, hey, don't be so deferential. Be a little more strict, right? Rosario, can I call you? Okay. What did the Fifth Circuit do after the case was remanded back to after the Supreme Court decision? They did the exact same thing. The exact same thing. So again, they got played, right? The court got played. Kennedy's like, let's send it back to the lower court. Hopefully they take care of it just it goes away. The Fifth Circuit did the exact same thing. They said, okay, we won't be deferential, UT still wins. Then Abbey appeals again to the Supreme Court a second time. Here's where things get actually a lot stranger. This is where history intercedes. When the case was argued, there were 9 justices on the bench. Scalia was very animated, and it looked like there were 5 votes to rule against UT. And at conference that week, I am certain there were 5 votes to rule against UT. Then on February 13th, 2016, guess another date, right before Valentine's Day, Justice Scalia passed away in West Texas. God, he did not have a CPAP machine on. It breaks my heart. It was next to his desk, wasn't plugged in, right to his bedstand. God, what a day that was. He died. At that point, the court was down to 7 justices because Kagan had recused. Had the initial vote held up, right, it would have been 4-3. Okay? Apparently, some more stuff went on behind the scenes, and Justice Kennedy decided to vote and change to uphold the UT program by a vote of 4-3. What's the worth of a 4-vote decision? It's not a majority. It's not a holding. We said this. You need 5 to have a holding. Justice Ginsburg told the New York Times that she expects Kagan will vote the same way in the future. So at the present moment, as far as the courts are concerned, I think affirmative action is fairly safe. Where I think they're on shaky ground is, again, federal funding. I think they're gonna get burned bigly by that. But the question here is, what changed from Fisher 1 to Fisher 2, right? So Jessica, what's Kennedy's reasoning for upholding the program after questioning it 2 years earlier in Fisher 2? Okay.
It says that the top 10% there alone would work.
Very good. So what the court basically says here is, if we are saying that there's this critical mass that they can achieve, and we'll defer to them defining what that is, this affirmative action plan is the most narrowly tailored way of getting there. That this top 10% plan won't get them what they want. right? Now, Jessica, let me ask you a follow-up question. Was that fact known when the case came up the first time? Are there any surprises about these numbers? Like, why couldn't Kennedy bring that opinion in 2014, the first go around? Is there a reason? Daniel?
Can you read that again?
Is there any reason why Kennedy couldn't have written this opinion 2 years earlier? Right? Is there something new that popped up that led to this conclusion? Anyone? Is there anything about Fisher 2 that could not have been written 3 years earlier? The record was exactly the same. There's alright?
About like the fact that now they actually apply and therefore like it met that test.
So what Rosario said is, well, the facts were always there, but until the circuit court applied the correct standard, they couldn't do an appeal. Okay, I'm more cynical than you are. The record was exactly the same. There is no reason in the world why the court could have done this 3 years earlier, or 2 years earlier. There's no reason at all. The facts were exactly the same. In fact, the circuit court didn't even send it back down to the trial court for further fact finding. They just affirmed it straight up. So, I'm actually most persuaded in part by Alito's opinion here, saying, look, something changed, right? What changed? Scalia died. That's the answer. Scalia died, the vote shifted, and Kennedy put his ring of approval stamp on the policy. But the majority opinion, which reads easy enough, you can read through Kennedy's opinion, basically says that we're going to defer to the institution. We're not going to demand any specifications of what amounts to a critical mass. And because of that deference, this policy will be upheld. Even if they could perhaps achieve these benefits some other way, we're not going to require them to do so. Okay. Yeah, Crystal.
Isn't that not applying strict scrutiny?
Oh, you stole my next question. I think we're reading each other's minds, right? So, Elizabeth, is this applying strict scrutiny?
No,
Why not?
because you're only asking the second part of the question. You're not asking the first part.
Right. What this opinion basically does is it writes out the narrow tailoring requirement, right? So long as the government argues that they are acting in good faith to achieve their compelling interest, you don't have to show narrow tailoring, right? Even though this policy looks a lot like the policy at the Michigan undergraduate school. Not exactly, but it's in the same ballpark. They say you don't need to show the narrow tailoring. Crystal, you seem perplexed by this.
I am, because then does that mean that to meet the requirement of strict scrutiny, you just need to prove that the means were in good faith to tailor?
Yes, and that's what Thomas argues, right? Justice Thomas's dissent here, and I mean, he's beating the same horse over and over again, right? He keeps saying the same thing. What Thomas basically says here is, this is not strict scrutiny, right? It's not strict scrutiny. It doesn't meet the requirements of strict scrutiny. Alito takes it even one step further and spends a lot of time talking about Asian Americans. This is a category that the Harvard suit implicates. The lawsuit I mentioned in Harvard is such that if you are an Asian American applying to Harvard, you're actually at a significant disadvantage. That it's going to be harder for you to get in than a white person or even an African American or Hispanic. It's going to be much harder. That the points cut against you because the argument is if we just admit on SAT alone, the school will be all Asian. And the effect of this goes back to Alan Bakke, right? That certain groups are helped and certain groups are harmed by this admission. So we're basically full circle, right? It's the same sort of idea. The only mistake UC made, University of California made, was by calling it a straight up quota. So long as you camouflage and massage it to look something differently, the courts will uphold it. But at least in the context of higher education, this requirement of narrow tailoring just doesn't really exist. So long as the university acts in good faith, the courts will defer to it, and that's into the matter. now. The same guy who brought the Fisher case, his name is Ed Bloom, filed another case against UT again, not in the federal courts, but in Texas state courts. So the Texas state judiciary is a lot more conservative than is the federal judiciary. So I think what we'll see in the next couple of years is does the state Supreme Court, does the Texas Supreme Court vote to strike down UT's policy? So this is not out of the woods quite yet. You can file the same lawsuit in two courts and argue that the Texas Constitution is even stricter than the federal Constitution. So this is not going anywhere. So even though Abby is out of luck, I don't know that this policy will survive the Texas state judiciary. So questions on Fisher 1 or Fisher 2? All right, let me summarize a bit and I'll let you go. The general norm of strict scrutiny is that when you have a suspect classification that is like race, you have to look at it very precisely and ask, what is the government's interest? Is it compelling? Is it raised to a certain level? You have to ask yourself, is the government narrowly tailoring its program to achieve that interest, right? In other words, can they use race in a less onerous fashion? Can they use race in a less explicit fashion? Compare division undergraduate policy to the law school policy, right? You can't have a straight 20-point boost, but race is considered a factor. But if you compare the use of racial classifications in affirmative action to other areas of the law, it's a different world, right? For one reason or another, when courts look at racial classifications for higher education, they give a much more deferential standard. They basically ask, is the university acting in good faith? And that's enough. Generally, when the government goes to strict scrutiny, they lose, except affirmative action. This is one of the rare outliers. And I'll posit a perhaps reason why, and this goes back to the Ginsburg-Thomas debate. I think the justices who vote this way see these policies as helping people. They're beneficial affirmative action, right? It's true, Mr. Bakke is denied admission, Abigail Fisher is denied admission, but it's helping a lot of disadvantaged people. Whereas Korematsu, you're locking people up in camps, that's not so good. So I think the way to understand these cases is, even though the court won't say it explicitly, they see that beneficial racial classifications are good, and then harmful racial classifications are bad. Anything else? I will see you on Thursday. Thank you.